Welcome everyone to today's webinar. I'm Julie Spitzer with Becker's Healthcare. Thank you for joining us for today's webinar, Workers' Comp Out of Network Isn't the Only Revenue Problem You May Have, sponsored by CollectRx. Our webinar today will be about 30 minutes. You can submit any questions you have throughout the webinar by typing them into your control panel in the space labeled Enter a Question for Staff and clicking Send. We are looking forward to hearing your questions. Additionally, in about a week following the webinar, we will be sending you a copy of the presentation to the email you used to register. At this time, it is now my pleasure to start today's webinar by introducing our presenters. John Bardo serves as CollectRx's Chief Executive Officer. Mr. Bardo is a veteran in the field of healthcare and information technology. As President of Dr. First Inc. and Executive Vice President of Promatics Inc., Mr. Bardo has specialized in providing cost containment services to health insurers and various products and services to hospitals, health systems, and other healthcare providers. Previously, Mr. Bardo was an attorney at Kirkpatrick & Lockhart, LLP, now K&L Gates, where his practice focused on litigation. Mr. Bardo's clients have included a wide range of for-profit and non-for-profit health insurers, including Blue Cross Blue Shield of Florida, Humana, Capital Blue Cross, Kaiser Permanente of the Mid-Atlantic region, Care First, and Blue Cross Blue Shield of Massachusetts. Mr. Bardo has also worked on behalf of numerous hospitals and health systems, including Henry Ford Health System and MedStar Health, along with hundreds of physician practices. During her 8 years at CollectRx since joining in 2010, Richa Singh has served in a variety of positions at CollectRx. Currently, Mrs. Singh serves as CollectRx's Executive Vice President. Ms. Singh's responsibilities include developing and implementing corporate-wide sales and marketing reporting and systems, overseeing the sales and marketing staff and functions, and serving as the lead relationship manager with the firm's largest clients. During her tenure at CollectRx, she has been instrumental in the firm growing its client base to more than 800 providers nationwide. John, I'll now turn the floor over to you.
Thank you, Julie. Appreciate it. And hello, everyone. I'm John Bardo, CEO of CollectRx, and we are very happy to be here today to talk about the opportunity to significantly increase collections by maximizing workers' comp payments.
And I'm Richa Singh, Executive Vice President of CollectRx. You may have known CollectRx as experts in out-of-network reimbursements, but what you might not have considered is that workers' comp is both an out-of-network and in-network problem. And we also have the expertise to handle both scenarios here. So today we want to talk to you all about the various issues related to reimbursements of workers' comp bills. And more specifically, we're going to be talking about, first off, CollectRx's expertise, so you have an understanding of why we're in the position to talk about this. Then we'll talk about the history of workers' comp, the opportunity to improve your collections by maximizing workers' comp payments, and then finally, some actual tips for maximizing workers' comp payments. And our objective when you leave here today is that you have a better understanding of some of the issues affecting workers' comp reimbursements and just how you might take better advantage of the workers' comp opportunity. John?
Before we dive into these topics, let me spend a minute or two giving you a quick summary of our experience in workers' comp and out-of-network bills so you understand why we're in a position to address these issues. Now, despite our name, we're not a collections agency and we have nothing to do with the pharmaceutical industry. Simply put, what we do here at CollectRx is we help providers get higher reimbursements on workers' comp and out-of-network bills. We don't do this as consultants, but as experts in negotiating and appealing in order to achieve higher reimbursements on your workers' comp and out-of-network bills. We are singularly focused on helping providers get higher reimbursements on these bills, and we've been doing it since 2006. We work with more than 800 customers nationwide and process more than $1 billion in bills each year, and we work with a variety of providers, including surgery centers, physician groups, hospitals, and labs. And there are really sort of two keys to the success that we achieve for our customers. One key is what we call CRIXIS, which stands for CollectRx Information Systems. And this is the proprietary data and analytics tool that we've developed internally here to support us as we go toe-to-toe with the payers. Crixus helps us analyze insurance policies, provides comparable data, and allows us to track the trends and tendencies of the folks on the insurance company side. And then finally, the other key to our success is, in addition to Crixus, we rely on our expertise. We've built a unique team of experts who used to work for the insurance companies and their vendors, and this puts us in a unique situation where we're able to understand the soft spots in the payer's position and get higher payments on bills for our customers. Richa?
All right, thanks, John. So let's now start the discussion with a little bit of a history of workers' compensation bills. And the middle of the 19th century brought a rapid rise of industrialization in the U.S., and this, along with it, brought extremely hazardous working conditions. Workers' comp is one of the oldest insurance programs in the United States, and it was created to help these workers recover from work-related injuries and illnesses. Workers with serious injuries, they faced long recovery times, and they often resulted in the diminished ability to function effectively. Many times these injuries, they led to the death of the primary household wage earner. As such, early workers' comp programs, they focused on providing compensation for economic loss that was associated with death. But today, the 50 states, District of Columbia, U.S. territories, they all have their own workers' comp programs. The goals of these programs, they've now expanded to include fast recovery from injury and return to work, and of course, they're trying to control claim costs. In fact, workers' compensation costs are one of the many factors that influence businesses to expand or relocate in a particular state. I mean, just think currently of Amazon's search for its new headquarters too, and the race among the states to attract Amazon to their location.
So workers' comp bills, they work like this. Regardless of how the workplace injury was caused, the employer agrees to accept liability for the injury. The employee gives up their right to sue the employer for injuries caused by the employer's negligence in exchange for the payment of benefits. Both parties agree to accept this no-fault concept regardless of who or what caused the accident. When a claim is processed using workers' comp, the insurance company pays 100% of injury-related costs for workers from day one. This means that there is no resulting patient responsibility for payment. Now, with respect to processing a workers' comp bill, there's many ways your reimbursements can be impacted or impaired. Once the provider generates the bill, it goes to the payer or funding source, which may be the insurance company, could be the self-insured employer group, or the state-controlled fund. Today, 80% of total coverage comes from both private insurance companies as well as self-insured employer groups, as the trend is for employers to move away from state insurance funds. The reason for this trend is that commercial companies streamline workers' comp much more efficiently than the states do. Now, oftentimes payers will hire a claims administrator to handle the processing details. And finally, it's not uncommon to involve a workers' comp company whose sole purpose is to know the state rules. They confirm claim compensability, funding source, jurisdiction, and fee schedule. An important note here is that balance billing the patient for amounts that the payer did not reimburse as a means to recover payments, that's not permitted in the majority of workers' comp cases. So really, the battle of reimbursements is between the provider and the payer. With so many entities involved, of course, plenty of errors are made in determining how these reimbursements work on a particular case. Richa? All
right, thanks, John. So now let's switch gears again, and now we'll discuss the workers' comp opportunity. And 90% of the nation's workforce is covered by workers' comp, which obviously means that there's a lot of workers' comp cases out there. The other 10% of the workforce is mostly domestic, migrant, and seasonal farm workers. So today, businesses, employees, insurers, states, they all benefit from programs that pay out over $62 billion in benefits annually as of 2015. And this number, it will continue to increase. There's going to be a growth in the number of employees and, of course, the continued rise in the cost of medical care. And because workers' comp is a state-administered program, compensation can be variable with respect to rules for claim handling, impairment evaluation, treatment guidelines, dispute resolution, and related cost control methods. Another major contributing factor depends on the state's fee schedule, if they have one. Because of all this variance, providers may not be compensated correctly and could miss out on their deserved collections. So in the next section, that's when we'll provide some tips on how you can recover on those missing collections. So this map here, it depicts fee schedule states versus non-fee schedule states for the payment of out-of-network workers' comp claims, where by definition there is no contract. Generally, most states have adopted fee schedules for professional fees, whereas fee schedules are less commonly used for facility claims, for instance, inpatient and outpatient hospitals or ambulatory surgery centers. Being a fee schedule state simply means that there are guidelines to how the payer will reimburse for workers' comp claims. There can be a variety of methodologies applied to determine the fee schedule. For instance, it could be a percentage of Medicare or even a percentage of bill charges. Now, in contrast, non-fee schedule states do not have a specific equation or designation for pricing, and there's more leeway to interpretation of how workers' comp bills should be reimbursed. But regardless, if you're in a fee schedule or non-fee schedule state, there's still opportunity to increase payments. So let me first start with fee schedules. And fee schedule methodologies, they vary greatly from state to state in a lot of different ways. First off, Medicare-based programs, they are becoming more common, but it's how it's implemented that differs from state to state. So some states like Texas, they may adopt a Medicare-based system, but they might choose not to strictly follow the Medicare claim processing rules. Also, the use of fee schedules in a state may not apply to other provider types. So for instance, let's take Arizona. Their physician professional fees, they did adopt a fee schedule, but the ASC facility fees did not. Another variations in state fee schedules is the varying percentages being applied to Medicare rates to determine the amount of the reimbursement. You may encounter a fee schedule defining reimbursements as 140% of Medicare, 200% of Medicare, or somewhere in between. And finally, further impacting payments are Medicare claim coverage rules that are unique to each fee schedule. So for example, ambulatory surgery centers, there are add-on code rules, and hospitals, they use OPPS package rules. Now, because of these differences, workers' comp reimbursements can be reduced in multiple ways. Payers often misinterpret fee schedule guidelines, and this is what can contribute to your bills being underpaid. Workers' comp regulations, they set compensation at a maximum limit, but some providers, they're still somehow accepting less than that max. And when it comes to jurisdiction issues, which state's fee schedule will govern? We're going to address both of these challenges in the next section. Fee schedules, though, they are an effective and widely accepted tool to control medical costs. We can expect to see continued updates to each state's fee schedules on a periodic basis. So for instance, 3.5 years ago, in January of 2015, Delaware, they transitioned from a non-fee schedule state to a Medicare-based fee schedule, and this led to an 11% reduction in their total workers' comp payments. So these constantly changing fee schedules, they will continue to confuse payers and providers alike and be cause for more misinterpretations of these guidelines.
So let me show you a few examples of fee schedules and demonstrate how they can differ by state. And for simplicity, we limited the service types to ASCs. The first one here is Louisiana and Louisiana's workers' comp fee schedule. It reads, outpatient hospital and ambulatory surgery services will be reimbursed at covered charges less a 10% discount. The formula for calculating the payment amount is bill charges minus non-covered charges multiplied by 0.90, that's your payment amount. This seems simple and straightforward. However, the term labeled non-covered charges is open for misinterpretation by the repricing vendors and can lead to significant unexplained reductions. Now, moving along here, you see North Carolina, which recently experienced an updated fee schedule, which now utilizes a Medicare-based calculation. In addition, North Carolina also adopted the Medicare processing language, and implants will now be considered inclusive. The Texas fee schedule is also Medicare-based, but offers a provider an option to choose whether or not they want to be reimbursed at the cost of implant material. The difference between the options is what multiple of Medicare will be used to determine the reimbursement level. Here's an example for the state of Oklahoma, based on the ambulatory surgery center fee schedule. This gives us 3 reimbursement options. It starts with continuation of maximum allowable reimbursement shall be limited to the lesser of, and then it gives 3 different alternatives. Option A, the ambulatory surgical center's usual and customary charge. B, 60% of the sum of all ambulatory surgical audited charges, excluding charges for implants. Or 3, the maximum reimbursement allowed under the inpatient hospital services ground rules for the same or substantially similar services provided in an inpatient setting. This is a good illustration of how complex workers' comp fee schedules can be. Often, payer interpretation of fee schedule guidelines is not always precise, and that contributes to your bills being underpaid. You don't want to just accept what the payer chooses out of the 3 options. You want to develop a strategy to challenge that determination. Other states like Illinois and Delaware use online fee schedule systems. This allows you to reference the fee by filling in the relevant information, such as service type, year of service, county location, coding, etc. Then you hit enter and pops up the fee schedule value. Georgia and Connecticut purchase their fee schedules from a vendor and are not posted online. Rather, they require you to purchase the fee schedule from their vendor. Now, there are some states like Iowa, New Jersey, Wisconsin, which have not adopted fee schedules to administer their workers' comp claims. These non-fee schedule states determine reimbursement based on a usual and customary for the service geography. If you have ever heard of any of our previous out-of-network presentations, you know that because usual and customary is such a vague term, that provides an opportunity to negotiate at a higher reimbursement rate. So how the determination of usual and customary is made is really not known by many providers, so let me just spend a minute or 2 on that here. And it starts with employer preference. When an insurance company sells to an employer group, the employer group has the ability to dial up or down the workers' comp benefits. There's a basic trade-off here, a trade-off between the provider discontent and the payment of premiums. The higher the premiums, the lower the discontent. The lower the premiums, the greater the discontent. The dials, they come in at different levels. First, does the payer negotiate settlements, and if so, at what rates? Second, what is the maximum allowed amount when bills are repriced? Third, if a provider pushes back, what should the payer do? It can range between what the payers call stand on data, meaning that it doesn't move at all to increase payment on one end, to making fairly drastic concessions to eliminate provider noise on the other end. This is a spectrum, and employers can choose to be anywhere that they want to be along that spectrum. And then finally, with respect to supporting data, whatever the employer chooses, the payer has data to support its position. And it's common for the payer to rely on a third-party vendor to manage that data and how it's being applied to pricing determination. Now, payers are constantly looking for ways to reduce payments to providers through bill minimization tactics when there is no fee schedule. The good news is that you're able to make more money by negotiating and appealing these workers' comp cases. And to do so, though, you need to have the data, the resources, the time, the expertise and experience to be successful. Richa?
All right, thanks, John. So that takes us to discussing some specific steps that you can take to increase your collections from workers' comp bills. These are things that we see every day as we go up against these payers on behalf of our customers. And remember, whether you are in a fee schedule state or not, or if you're contracted or not, payers and vendors that work for them are continuously looking for ways to underpay your claims. So there are 5 areas of improvement that we're going to discuss to help maximize your workers' comp reimbursement. The first is to initiate a post-payment review process because potential underpayments must be identified in a timely manner. The second one that we'll discuss is confirmation of the jurisdiction state, which defines the rule for payment. Third is a rigorous negotiation and appeal process. 4 is a thorough understanding of your workers' comp contracts. And 5 is to review your explanation of reviews. So let's go ahead and dive into these in a little bit more detail, and we are going to start with the post-payment review. So it is critical to identify underpayments before appeal limits are exceeded. And yes, it is a time-consuming process, but there are options to build a program that fits your resources. So first off, depending on the number of workers' comp bills you generate, plan to review all if it's possible. But if you do have a larger volume of workers' comp cases, alternatively, what you can do is build criteria to limit the number of EORs reviewed to those that are most likely to be underpaid. So the type of factors that you can look at or focus in on are the ones that are larger dollar sizes, the bills that have multiple lines of code, bills with implant charges, and even specific payers. We do recommend a review process that's continuous versus spot checking. That way you're able to catch every error. And we do recommend reviewing every explanation of review against the bill. You need to look for clues that hint at underpayment. So you want to look for things like confirming the jurisdiction rule that applies. You want to confirm that the EOR remarks are consistent with that jurisdiction rule. Decide if pricing is what you expected per what you were billed. Look for any denials or zero payments. And finally, review timely filing rules. Most states, they do allow 1 year to submit a workers' compensation appeal, but there are exceptions that only allow 60 days.
So let me talk about jurisdiction for a moment here. Jurisdiction is what determines the state under which the claim will be processed. It's important to know the rules of your state as well as bordering states. So we're often asked how the insurance companies determine jurisdiction. And the jurisdiction determination takes into account various locations relevant to the claim that includes the following: state where the claim was filed, state where the injury occurred, state where medical care was rendered, state where the employer is located or incorporated. And oftentimes the answer is simple. It's really just one state where all 4 of these above, they all occur in the same state. But the decision can get more complicated when the employer's truck driver is injured in one state, lives in another state, and gets medical service in yet another state. And it's not uncommon to see national companies incorporate in states where the workers' comp law is most advantageous to the employer.
Okay, and then the next topic that we're going to go into describes how to have a rigorous negotiation and appeal process, in which you're going to see some commonality to negotiating out-of-network bills, especially with non-fee schedule states. So we're going to start with reviewing the process first and how a workers' comp bill gets processed. So it starts with the provider generating a workers' comp bill, and then it goes to the payer or the funding source. And as John had mentioned earlier, this can be either the insurance company, the state-controlled fund, or the self-insured employer. Again, oftentimes payers will hire a claims administrator to handle processing details, and they'll hire a workers' comp company to understand and implement the state rules. But as you can see, there is input from many different parties, which increases the chances of improperly reimbursing a provider. So pricing determinations are dependent on the particulars of the jurisdiction state and whether the provider is contracted or not. But regardless of any of these factors, one of two options are taken by the payer. Either the payer just sends a payment to the provider, or the payer attempts to negotiate with the provider prior to payment by sending a settlement offer. But whatever the choice, the payer is always trying to find the lowest pricing option. So if the jurisdiction is a non-fee schedule state, reimbursements are based off of usual and customary, so there's room to negotiate there. But even if if you're in a fee schedule state, or if you have a contract with the payer, you still may be able to negotiate for additional payments. So let's take the top picture. When a payer just makes a payment, remember to check your explanation of reviews. Payers may not have interpreted the fee schedule correctly, or they just did not pay the correct contracted language. So there may be room to do better. And in the second picture below, when a payer sends you a settlement offer and you're in a fee schedule state or have a contract, then they're trying to beat your fee schedule. So it may not always be in your best interest to negotiate in those instances, but if done correctly, sometimes you can negotiate a small percentage off the fee schedule and get your money in much faster. For providers that are in a state that does not have a fee schedule, you want to negotiate every offer. That way you can maximize reimbursements to as close to bill charges as possible. So let's go into some specific tips for appealing underpayments or denials. So the first tip here is that a written formal appeal is the best method to advance your dispute with the payer, especially if your dispute is complicated. Verbal reconsiderations, they may be attempted for simpler matters like when it appears a processing error has occurred. Next, mailing an appeal rather than faxing is key. Certified mail is slower and it includes additional costs, but it provides confirmation that your appeal has been received and is recommended for larger dollar appeals. You can also make a follow-up call to ensure that the appeal was received. The next tip is to include documentation to support your appeal, such as operative reports and implant logs and invoices. Also, always include the date of injury and claim number on your correspondence so the payer can identify your claim quickly. Remember, your patient may have other dates of injury from the past for the same or different body parts. Lastly, many payers will redirect you to contact a repricing vendor for questions and disputes. This may be a diversionary tactic. We prefer to direct our appeals to whichever party is responsible for the payment. So here is an example of an appeal response received from a third-party vendor, and it's meant to discourage you and get you to give up. In this example, the appeal was directed to the payer, but then they redirected it back to the third-party vendor to deal with the matter. Payers may take the stance that the payment decision was not made by them, and therefore they're unable to change the prior determination. So this is when it might be a good time to call to a higher level. The success comes to those who know how the bills should have been paid. And then finally, in this part, I want to discuss some of the tips of negotiating settlement offers as well. Here's just a couple of things to keep in mind. So first off, persistence. Do not give in easily if you think their offer is inadequate. The payer and the vendors, they put up obstacles to success, banking literally that you're going to get up and walk away. They know you're busy, that you don't have the time to continue the fight. Second point here is data. You want to obtain and track the data to prove that the payer's payments are inadequate. At CollectorX, we use our CRICS's database, of course, but you'll also need to be able to argue that the insurance company's reimbursement level is inconsistent with your own history and preferably the history of other providers in the community. Remember, they are tracking everything that you do down to the names, titles, and discount levels of everybody in your business office and what they give. And then finally, focus. Have a plan and stick to it. It's just not going to happen. It needs to be part of how you do business.
So now let's look at having a contract directly with a workers' comp company. The key issues to consider with respect to a workers' comp contract include the following. First and foremost, is there a valid business reason to continue participation in a contract? Many contracts discount the mandated state fee schedule, so you're accepting less than the state designated maximum reimbursement. For non-fee schedule states, you lose the ability to negotiate closer to your billed charges. With workers' comp contracts, there is no true patient steerage to make up for that discount. You may want to ask yourself why you're bothering to be in such a contract. Have you reviewed the contract recently? Many contracts are aged and they haven't been reviewed in years. State workers' comp fee schedules are undergoing continuous change. It may be time for an update. Third, confirm payer access to your contract and ask for a copy of the pricing sheet, because that's what will show you how the payer is paying that individual claim. You need to make sure that the pricing sheet matches the way your PPO should have reimbursed for your contract. So in sum, take serious consideration into it if you really need to have a workers' comp contract. Finally, you may want to review your explanations of review, or EORs. Whether or not you're in a fee schedule state, payers are always trying to underpay providers. No matter what, you should always read your EORs to see if there's an opportunity for additional payment. Just because you're in a fee schedule state doesn't mean that the payer is going to pay correctly. EORs can be difficult to decipher. An important tip to remember is that the third-party pricing vendors commonly label their determinations as recommendations to the payer. So ask the question this way: is the recommendation supported by the state jurist rule, for example? Is the workers' comp claim being allowed the state fee schedule? So over the next couple of slides, we've inserted examples of actual language from EORs that show how misleading they can be. But there are always clues to be mined as you're putting together your argument to go to the payer. So let's take a look at these EORs to see how payers make it difficult for you to understand how they are reducing your payment. The first example reads, review to standard of reasonableness based on comparison to industry benchmarks of charges and reimbursement for services in the area. This statement contains none of the information that we would require, other than perhaps the for services in area quote, and makes it difficult, makes a subtle reference to Arizona, where the provider is located. No explanation or reference is offered to explain whose standard or what the industry benchmarks were used in their determination. The jurist did not support the pricing recommended. It was challenged, and an additional payment of over $4,000 was successfully rendered. The next example reads, unless otherwise noted, charges were reduced for exceeding the guidelines of the physician's fee schedule of the state of Arizona. Both this and the previous example were for the same provider and repriced at the same company using different remark details, and both were facility claims. So can you guess what issue that we had with respect to the second remark? Yes, the reference to the physician's fee schedule for an ASP. We challenged, and an additional payment of more than $34,000 was successfully rendered. The next example is usual and customary language. See the quote here, unless otherwise noted, all reimbursements below billed charges are based on the 80th percentile of usual, customary, and reasonable for this geographic location in which services were performed. We confirmed the jurisdiction and challenged the payer's determination of usual and customary, and an additional payment of $11,869 was successfully rendered.
All right, a couple more of these examples. So this next EOR reads, this bill was reviewed using the Industrial Commission of North Carolina Workers' Compensation Fee Schedule. So this is much more informative and confirms the jurist rule, which is definitely helpful for us. There is a specific fee schedule that applies, but this bill was further reduced using a valid workers' comp contract. So what we did was we disputed their contract interpretation and the mixed application of claim processing rules, and an additional payment of $5,500 was successfully rendered. And then this final example is showing that even when you successfully appeal for an additional payment, sometimes continuing the appeal will yield a second additional payment. So in the example here, there's 4 remark codes, and they come from a single case that required 2 appeals. Both were successful. So let's look at the first set of EORs, or remark codes. And the first remark code says, Illinois workers' compensation case repriced in accordance with Illinois rules and guidelines. The second remark code says, implant invoices required for further review. Please provide proof of acquisition costs from the vendor. So this was Illinois jurisdiction, but it had service in Indiana. The implants were allowed at $0, and our first appeal rendered an additional $2,369. So then it reprocessed, and we got a second EOR. The first remark code stated reimbursement for this service based on the IWCC regulations for out-of-state providers. Second remark code says implants reimbursable separately at cost plus appropriate markup, cost determined by a professional review. So the second appeal corrected the underpayment for absence of the markup, which is 25% above cost, and we rendered an additional $792. So in total for both of these appeals, we appealed for an additional $3,161. So if there's one takeaway that you take from today, it's to check your EORs, because if you don't, frankly, you are losing money.
So finally, let me wrap up with a word or two about outsourcing and the importance of outsourcing to companies that are well seasoned in the reimbursement arena. Even if a provider has the skill, the expertise, and the data to be successful with workers' comp reimbursement, they often don't have the time. And think about the fact that the payers, with their vast data and resources, they don't handle it themselves. So if they outsource it, shouldn't it at least be something that you consider? So finally, let me just wrap up here. Hopefully you have a better idea of what's happening today with respect to workers' comp. And also remember that when done right, proper workers' comp reimbursement management is an important tool providers have to improve financial performance. So I thank you for your time. I hope you found this session useful. Let me turn the floor back over to Julie. Julie?
Thank you, John and Richa, for that fantastic presentation. That's all that we have time for today. We're sorry for running out of time, but feel free to reach out to CollectRx with any unanswered questions. I want to thank our webinar sponsor once again, CollectRx. We hope you have a great rest of your day and can join us for future webinars.